A battery on a police officer is a very serious offense, not just related to the consequences you face in court, but the simple fact is, if you have a conviction for this offense, you can probably expect a fairly unpleasant contact with law enforcement anytime you get pulled over in the future. A battery on a police officer does not just include police, but it also includes firemen, marshals, court officers, and correction officers.
In order to prove their case beyond a reasonable doubt, a prosecutor has to show two things. Number one, that the officer was on duty, and number two, that the defendant, our client, knew or should have known that the person was a police officer. In a situation where an officer is on duty, in uniform, in a marked squad car, it's pretty obvious. However, if the officer is in plain clothes or an unmarked car, we may be able to argue that our client did not realize that that person was a police officer.
If the police officer involved did not suffer substantial bodily harm, then a conviction for battery on a peace officer is a gross misdemeanor here in Nevada, which means that you could face up to 1 year in local county jail. On the other hand, if the officer did suffer substantial bodily harm, and that would be broken bones, contusions, cuts or lacerations that required stitches, if the officer suffered substantial bodily harm, then it's a Category B felony that carries 2 to 10 years in Nevada State Prison, and can actually be up to 15 years if a weapon was used.
A battery on a police officer is the type of charge where many innocent people get wrongfully accused. The good news is, here at the Las Vegas Defense Group, we have a successful track record of litigating these cases in order to get them dismissed or reduced.
Another common defense is that the officer is lying or exaggerating. And quite frankly, I think that happens all the time in these sorts of cases. It's often a situation where the police don't like a particular suspect, he's rude, he's mouthing off to them, so they will simply add on or tack on a charge of resisting arrest or assault on a peace officer, even if that never happened, just to really stick it to the person and increase their charges. Or we have situations where the police literally will go out and beat someone up for no reason. And fortunately, I think that now with cameras on patrol cars and cell phones, this is becoming less frequent, but it still happens. And when they bring him to the station, the suspect has welts and has swelling and has injuries that get photographed, and they have to take the suspect to get a medical evaluation, and the police have to justify why they beat the person up. So they say, oh yeah, he took a swing at officers. He was combative. He took a fighting stance. And so we were just defending ourselves. And the real tragedy in this situation is not only did the police wrongfully and unnecessarily beat up a suspect, but then they lie and exaggerate and make up phony charges against that subject to paint themselves as the victim and to make the case worse against him.
Another defense to battery on a police officer is accident. For example, the officer tells you, put your hands behind your back. In doing so, there's an elbow movement. Or the officer tackles you, and in the process of falling to the ground, the officer gets hurt. This may be a case where it was simply an accident, where there was no intent to commit a battery on the police officer. In that scenario, where any contact you had was accidental, you should not be held criminally liable, and we stand a great chance of getting your charges reduced or dismissed. If you've been arrested in Nevada, call my legal team at 702-DEFENSE. The attorneys of the Las Vegas Defense Group will fight to get your charges reduced or dismissed.